Well, good afternoon, and thank you for joining us for our virtual alumni workshop on understanding estate planning. Before we begin, we're going to take a moment here to pause so that everyone has a chance to log on to the webinar. While we wait, feel free to type your name, grad year if you're an alum of UMD, and what brought you here today in the chat box, and we will begin in just a moment. Well, my name is Molly Clevin, and I'm from the University of Minnesota Duluth Alumni Relations team. In today's Alumni Career Workshop, you will learn about the fundamentals of estate planning. Today's session is a webinar format, meaning you have the ability to engage using the chat box and the Q&A function. If you have a question for our presenters, please use the Q&A button on the bottom of your screen. I'd also like to note that personal questions are unable to be answered in today's webinar. Now to introduce our guests. Today we are joined by UMD alum Vince Darling and attorney Elizabeth Scott. Vince has been in the financial service industry since 2018 and became a certified financial planner in 2022. He graduated from UMD in 2019 and went on to work with the Stonebridge Group as a financial advisor. He specializes in comprehensive financial planning, investment management, tax planning, student loan planning, and retirement planning. In his spare time, Vince often travels back to Duluth with his wife, Sadie, who is also a UMD alum. He enjoys golfing, water skiing, mountain biking, and being a bulldog. Elizabeth of Heley, Duncan, and Melander practices in the areas of estate planning, trust, and probate administration. She works with families to determine the best disposition of their assets while also working to minimize any estate taxes. Following the passing of a family member, Elizabeth works with family members to ensure those plans are properly executed. She frequently works with clients and their financial advisors to properly title assets. It is now my pleasure to hand it over to Vince and Elizabeth.
Awesome. Thanks, Molly. Appreciate the introduction. Glad to see everyone here today. Glad to be back doing another financial presentation here along with estate planning. And I'm glad to have Elizabeth on the call with us today, giving her law perspective on things. So Elizabeth, anything you want to say before we get started?
No, I'm excited to be here. As most of you probably know, an estate plan is important, but even the best estate plan may mean nothing without the correct financial aspects to it. So the combination between Vince and I, we should be able to be pretty informative for everyone today.
Yeah, and I think Elizabeth and I would both agree, we wish we had, 3-4 hours to go over all these things. But, with the hour we have, we're going to try to fit as much as we can possible. But, we're not going to get to everything in such detail. So we'll get started. Integrating estate planning into your financial strategy. Let's see. I just want to have a quick disclaimer here. This presentation is for educational and informative purposes only. Do not consider this advice. Please consult with your own financial advisor, tax advisor, legal advisor, or any other professional before making any decisions of anything that we talk about today. The agenda that we have. So we're going to be talking about wills, trusts, the differences, similarities, thoughts when choosing the right one for you, 401ks, IRAs, annuities, what happens when you inherit those type of investments, kind of what's the tax implication. We're going to go into brokerage accounts, real estate. We talk a lot about gifting with clients of ours, or, is it best to wait till time of death and transfer at that point? We're going to bring up a little bit about estate taxes, powers of attorney, considering appointment or appointing an attorney, in fact, and then healthcare directives. So that's kind of the agenda today, and we'll just get rolling. Take it away, Elizabeth.
All right. So to understand estate planning generally, there's sort of a fundamental thing you need to understand, and that is the difference between probate assets and non-probate assets. Non-probate assets are going to be assets that have beneficiary designations that you appoint your beneficiaries. That means you don't need to go through the probate process when someone passes away. So if you're working with a financial advisor like Vince, on your IRAs, you'll have beneficiaries listed. That makes it a non-probate asset. Same thing with life insurance. As long as you have beneficiaries listed, that won't go through a probate proceeding. Probate assets are assets that are titled solely in your name. So if you own a house by yourself, you own any assets that are just in your name with no beneficiary on it, that's a probate asset that will have to go through a probate proceeding, which is a court proceeding where the court determines who is in charge of the estate and who will administer it, and then ultimately who the beneficiaries are. And then the last sort of category are joint assets, and those just pass outright to a surviving joint tenant. The most common example of that is going to be a house that spouses own as joint tenants. And joint tenants means there's right of survivorship. So the surviving spouse automatically gets that. But then once that surviving spouse has it, it's titled only in their name. So then that could become a probate asset.
Gotcha. Elizabeth, talking about probate, that's kind of the biggest word I tend to hear when clients come into my office. So why are people, worried about probate? Why do people want to avoid it as much as possible?
You know, probate isn't quite as scary as I think people tend to think it is. Depending on your situation, it can be a pretty easy process. It is costly to engage in a probate process. Typically, you retain an attorney. The court filing fee, depending what county you're in, is around $300. And then there's a publication fee you have to engage in. It's going to be in the probably thousands of dollars to go through a probate proceeding. Whereas if you could make your assets non-probate assets, and there are ways to do that through trusts and other transfer on death or payable on death deeds, you can do it that way. But I think people get scared because it's a court proceeding, it's all public then, and it can be costly, and there are more issues that arise in probate proceedings than you would want to know because people fight over a lot of things. So it sort of invites issues.
Gotcha. And not to mention not money, but the issues and time tends to be another one that people bring up, just the amount of time it takes to go through the probate process.
Right. Pre-COVID, it was not such a painful process. Now that the courts got so backed up during the pandemic that at least in Hennepin County, sometimes it'll take 6 months to even get someone appointed to be personal representative. And that's the person in charge of administering the estate. And that's 6 months where no one can touch any of the assets. So that's a significant period of time. Whereas if you didn't have to go through the probate process, things can be dealt with immediately.
Gotcha. Wills and trusts.
Yeah. So a trust and a will are similar in some ways, but also different. A will does not own any assets. A will is something that appoints who's going to administer your estate and then who ultimately you want to receive your assets. A trust is a legal document that actually owns assets. You would be the person who creates it and likely the trustee while you're living. And your house would likely be owned by your trust, and other assets are owned by your trust. And that trust specifies then when you pass away, who you want to receive those assets without having to go through a probate proceeding. So there are some, significant differences between wills and trusts, as we discussed. One important thing to understand about a will is, and I'm not going to get too in the weeds on this, but if you have a trust, you always have a will that goes with it, and it's known as a pour-over will. And the purpose of that is if you ever buy an asset and forget to title it into your trust, that will say, put whatever was not titled into my trust. But the big thing with a will is that, especially for young couples, that's where you appoint who would be guardian of your minor children. That's who would take physical control over your children. And that's always done through a will and not a trust. Otherwise, trusts, they become effective. Typically, a revocable trust for the purpose of this conversation immediately. So immediately once it's signed, typically people deed their houses into the trust, and then that's the legal entity that owns your assets. Wills, nothing really matters until you're gone. The trust, you can manage the assets while you're living, but the will, nothing happens until after you die. And the other thing with the will is you can revoke it, you can tear it up, you can do whatever you want, and last in time control. So as long as if you have done 10 over your life, and I've had clients who've done a lot of them over their life because life circumstances change, you can redo them, and it's just the last one that was signed, notarized, and witnessed that gets to control. Most trusts, for the purposes of this, are going to be revocable while you're living. There are irrevocable trusts. That's typically a more advanced estate planning tool for tax purposes, that they would become irrevocable, or if there's some concerns about beneficiaries and so forth. But most can be revoked while you're living, and most can be amended while you're living. Again, if you do your trust properly, you get to avoid probate. If you don't, you have to go through the probate proceeding. It takes time. A trust is going to cost more to set up, and it's because it's another legal document, and they're very detailed documents about how you want your assets managed once you're gone and while you're living. A will is, at least in my practice, significantly cheaper to set up than a trust. But then again, you have to go through that probate proceeding, and that is going to be, like I said, thousands of dollars. So it becomes a cost balance. For a lot of people, wills are appropriate if they're young couples and they just need a guardian appointed in case something happens to both the husband and wife. Perfectly fine. But once you start creeping up into a higher asset class, a trust is probably going to be the more appropriate solution.
Yeah, and just to touch on that, like just from clients that come into my office, one of the biggest things I hear is, oh, I have a will. I don't have to go through probate. That
Not
is
true.
so far from the truth. A will is just a document that's read at the probate process of how things go. So I thought that was a big one that I tend to see. Another one is, Elizabeth touched on this, is you put a trust together and then you have to list things in the trust. So many times I'll have people have a trust, but they don't list anything in the trust. So if nothing's listed properly, as it says there, to avoid probate, it has to be done properly. You can just put this whole trust, put it all together, but at the end of the day, you didn't do anything.
I see that all the time where people, they put their house in there, and then 10 years later, they go and buy a cabin and they buy it in their names. And then we have to go through a probate proceeding, because had they just put that into their trust, the trust would have dealt with it. But because they didn't take that one extra step. So if you do establish a trust over your life, you got to make sure you're putting your assets into the trust. But, for a will is an appropriate solution for a lot of people and a lot of scenarios. And it really depends on your financial situation. And, if you own a business, if you own a house, all sorts of things. So it really depends on each specific situation.
Yeah, and just listing beneficiaries outright. Another solution
Right.
that a lot of people don't just think of it that way. So anything else you want to touch on before we go on?
I don't think so on that.
Awesome. Perfect. Well, that kind of concludes the wills and trusts. One thing I wanted to really talk about is retirement account taxability after death. I have many people come to me stating, hey, I have this inheritance, none of it's taxable, which that can be farther from the truth. Every account has a different way it's taxed and different rules you have to follow when it's inherited. So I'm really going to jump into those situations. Elizabeth, feel free to chime in if anything you see on your end. But I just want to say, refer to your tax advisor regarding your specific situation. There are so many rules, and not to mention rules, but new rules that were implemented in January of 2020 with the Secure Act. So just take what you can from here, learn from it, and just know there's, your situation could be a little different. So jumping in, a lot of people have traditional IRAs, either, ones they started or ones they rolled over an old 401k into, or maybe they've retired and they moved it into an IRA. So let's kind of paint the picture here. So let's say you had this traditional IRA, and you passed and ended up going to your children. So with that, your children have pretty much the option of a 10-year rule. And we're talking about rules after 2020, meaning, okay, after 2020, you passed away, it went to your kids. There's normally a 10-year rule, meaning they have to take that whole traditional IRA and drain it out in 10 years. Now, if you were taking required minimum distributions, or RMDs, that many of you have probably heard, it's just the IRS saying, hey, you didn't pay taxes going into this account, but we kind of want you to start paying taxes now. So we're going to force you to take some of it every year with this calculation that we've created. So if you were taking your RMDs during that year, new rule states that, hey, in years 1 through 9, there's going to be a calculation and the inherited, so the child would have to take an RMD during those years. And then by year 10, the whole amount has to be drained out. So you can imagine if you have $1 million traditional IRA, that $1 million is fully taxable. Now, you can take that out within that 10-year period. So you might, take a certain amount out in year 1, 2, 3, 4, or some people just delay it and just take, those small RMDs and have to take this large lump sum in year 10, which could
Vince,
push.
what do you recommend with people that are high income earners? So if your kid is a doctor and they're making $400,000 a year, what would you recommend in that sort of situation generally?
Yeah, so when we're looking at that, we're trying to reduce the taxes as much as possible. So it's more looking at we're working with tax advisors and being like, hey, they're making this much income. They have this $1 million inherited IRA. How do we keep it in the lowest taxes amount possible for those 10 years? So we might just completely disregard the small RMD they have to take out and take out much larger sums to kind of cap it out at a certain tax rate. So if it's if they're in the 24%, but if they took out more, it would push them to the 32. We're trying to keep them in that tax rate of the 24, so we don't have to add another, 8% or 6% taxes or push them up even higher. So in those type of situations, it's really looking at that tax rate.
What about people who passed away pre-2019? Are they subject to the 10-year rule?
They are not. They have the ability to stretch out the IRA. That is a little more forgiving where, we don't have to drain this thing out in 10 years. There's also a 5-year rule back then. Different beneficiaries, but like I said, every situation is different. But for most people, it's that stretch IRA, or they can take it over their lifetime. But these new rules for the Secure Act of this 10 years is really making it more important to plan for it, because you don't want to pay 40-50% in taxes on an inheritance. I don't think anyone would want to do that. So there's ways you can tax plan when you inherit things like this. Spouses have additional options. They can treat it as their own, or pretty much move it from the inherited account, or move it from the deceased spouse's account into their own. What a lot of people forget is if you move it into your own, you still have to satisfy that 59.5 rule. So if you are under 59.5 and you roll it into your own now, and you're only 58 and you want to take a withdrawal, now you trigger a 10% penalty on top of the taxes. So that's when it's, choosing the right option, because that spouse could also put it into an inherited account, stretch the account, and not have to worry about the 59.5 rule. It's just all these different things you got to think about when you inherit these type of retirement accounts. But traditional IRAs, want to leave you with this. Most people, it's got to get it drained out in 10 years. Spouses have an exception. Others have exceptions as well. There's a whole chart about it. Designated beneficiaries. It's non-designated beneficiaries, whole thing. But 10-year rule and traditional IRA money, all taxable money that comes out. Roth IRAs. Many of you probably have Roth IRAs. Biggest difference here, same kind of rules when it comes to taking money out of, hey, got to take it out in 10 years. You have RMDs that you have to take out 1 through 9 if the deceased was taking out RMDs. If the spouse or the deceased spouse wasn't, then you just have to make sure you drain it out in 10 years. But the one largest difference is none of it's taxable. None of it's taxable as long as it was opened for 5 years. So any money that was put into these IRAs are all tax-free coming out. But any earnings in those accounts, if it was less than 5 years, could trigger some income taxes. So be aware of that. All right. Moving into 401k plans, pretty much similar things. There's the traditional 401k plans, and what had become more familiar or really more popular is the Roth 401k plans. They follow very similar rules to the rules of the IRAs. So the 10-year rule, spouses have the ability to treat it as their own, have the ability to stretch it out. But same thing when it comes to if the spouse was taking out the RMD prior to decease, you have to take out RMDs in years 1 through 9. And same thing, if a spouse, takes this traditional 401k or Roth 401k and moves it to their own, they have to be weary about that 59.5 rule, so they don't trigger that 10% penalty.
So Vince, something really
yeah.
important, all of both the 401k, IRA, and Roth IRA is having your beneficiaries updated all the time, correct?
Yes, I see it all the time. Luckily, with many 401ks and Roth 401ks, normally spouses have to sign off saying, "Hey, I'm not going to be the beneficiary" in most of these cases. That rule kind of changed, but I'm curious from a legal standpoint. If there was a divorced spouse, I see this all the time. Couple gets divorced on their IRAs, they have their ex-spouse listed, didn't get it updated. What's the implications of that on a legal side?
Sure. Under Minnesota's divorce statutes, they're presumptively not the beneficiary. I do have some clients who they're divorced, but they still want their ex-spouse to be the beneficiary, or they're required by their divorce decree to maintain the ex-spouse as the beneficiary. But presumptively, they shouldn't be. But I also often see where people get married and they still have their brother and sister as the beneficiary rather than the new spouse, or spouse dies and the kids they forget to put the kids as the beneficiaries. So you should check with your employer and then whoever your financial advisors are to make sure that those beneficiaries are how you want them to be.
Yeah, let's bring this back into the trust situation. So many times I'll have clients come to me and say, "Hey, my IRA or my 401k, the trust is the owner," and I kind of give them a look like, I don't think that's possible. Mainly, you can't list a trust as the owner, but what can you do once you set up a trust and you want the trust to inherit any kind of 401k or IRA?
Typically, I would say in 98% of situations, you don't want the trust to be a beneficiary, and you don't want the estate to be the beneficiary of a 401k or an IRA because of that stretch period gets shortened. So I typically say for retirement accounts, leave it to individuals. If you have a brokerage account, I have no problem with, that being owned by the trust. But when it comes to retirement, because of what the Secure Act did and how that changed everything, to the extent you can avoid it, avoid having your retirement accounts go to a trust or to your estate.
Yeah, and I see that all the time. It's sometimes the trust just lists, "Hey, I want it to go to my 3 kids equally." Well, you can list that as a beneficiary designation, and then it never has to read the trust.
Right.
But I still have people listing their trust. But I always say, hey, if it's more complex than that, maybe you don't want a kid having a certain amount of money in a certain amount of time. I know that gets a little more in the weeds of, hey, we got to set this up properly because you still got to adhere to those Secure Act rules.
Yeah, it gets really complicated. And there are specific situations where, someone has a child with chemical dependency issues and there are concerns about them receiving that. And sometimes people say, I would rather forego the tax consequences to keep that money out of the kid's hands. And then there's specific drafting things attorneys can do to try and protect, because you're right, we still have to adhere to those distributions, but there are other things that can be done on the back end by attorneys to try and deal with some of those issues.
Great. So one of the biggest things that come up is, hey, we know, and this is prior to death, hey, at age 7, well, it used to be 70 and a half. They moved it to 73, 74, 75, depending on your date of birth. But you have to take out required minimum distributions. And some of you might have already planned those out. And you can see, your income going up, depending on the size of the IRA, the traditional, or the 401k traditional side. Shooting up your income an extra 70, 80, $100,000 a year because you have these large IRA balances. And, what are some things that people come and say, hey, what can I do? I'm trying to limit my required minimum distribution because with, my pension money that I get and this required minimum distribution, I'm getting forced into a tax bracket that I really don't want to pay. It's, 24 to 32, higher than that, 35, 37, one of those. And now a lot of your retirement money that you saved so much for is now getting taxed. So, what are some things we can do in before time of death? Things you can look into, spending it. You saved it. Why not spend it? This is why you saved the money to begin with. Another thing you can start looking at, Roth conversions tend to be a big play once you retire, or possibly before retirement. But Roth conversions allow you to take a lot of that big bucket pre-tax money to pay the taxes and then move it to a Roth environment. And that, not only helps reduce your RMDs in the future, but if it's inherited down the road too, maybe you have kids that are making a good income, reducing their taxability once they inherit it. So, taking care of the taxes now instead of having to pay it down the road.
So is that
One,
true, Vince, for owners of the Roth 401ks or Roth IRAs, and then the beneficiaries? Is it the same tax consequence for both?
say that again.
Is the owner, so if the owner uses their own Roth down the road, is the tax consequence the same for them for pulling from their Roth as it would be for a beneficiary?
Well, it's going to be not taxable if that's what we're getting at.
Yeah.
So, we're trying to pay the taxes of what you want to pay. So a lot of times we'll when you're creating a strategy, it might be, hey, we don't want to pay more than 24%. So we're going to do these Roth conversions because it's going to increase your income during these low earning years once you retire to try to pay a lower amount of taxes. And then that money gets moved over to the Roth. And then guess what? That grows tax free as well. So it's quite a benefit of the tax savings that could take place. Another thing that comes into this is Social Security. Social Security is another big player. So people say, hey, I'm going to take Social Security at 62. Well, if you're doing Roth conversions, that's going to, the way Social Security is taxed is it's taxed on any other income that you receive, is how much of your Social Security is taxed. So it might make sense to delay Social Security for a few years while you're doing Roth conversions. Or, maybe it doesn't matter. You can actually still do both. So Roth conversions, a lot of stuff to talk about there. And a lot of people think you have to retire prior to doing a Roth conversion. That is not true. You can do it at a younger age as well to start moving some of that money.
Vince, what does a QCD stand for? I see it as a question, so I thought I might as well answer it now.
Yeah, so QCD, Qualified Charitable Distribution. This is another way. This is once you turn 70 and a half. So once you turn 70 and a half, you have the ability to take some of that pre-tax money and give it to some charities that you want to support. They have to be 501c3 qualified. And by doing that, let's say you take, a $2,000 amount that you withdraw out of the IRA, you can send it directly to that charity. And that $2,000 that would normally be taxable to you is now not taxable because it's going directly to the charity in a qualified charitable distribution. You have to be at least 70 and a half to start those. And one thing that I always recommend is you have to make sure you get a receipt. A lot of people don't have the receipt of where they gave the charity to. And, if the IRS ever comes back, they're going to want to see those, receipts that, hey, you did give them this cash and you got a receipt back for it. And you didn't get anything else for donating because they deduct that off as well.
There was a recent Minnesota Supreme Court case on this where they didn't have the letter from the charity saying they didn't receive anything for their or for their contribution, and then they weren't allowed to do it. So it's kind of a fascinating thing. You have to be careful about when you do those and work with someone who's going to be advising you because those things become more complicated.
Yes. And one of the biggest mistakes I see is they take the withdrawal out of the IRA and then send it to the charitable place that they want to give to. That now makes it non-qualified. It has to go directly from the IRA to the place that you're giving the charitable giving to. So just keep that in mind. All right. So, touching back, hey, how do we reduce some of that big pre-tax? I call it the tax time bomb money. Spend it doing converting some to Roth, some charitable giving, and just planning around those tax brackets. Jumping in, we got annuities. I'm assuming many of you have either owned an annuity yourself, have inherited an annuity, or maybe even looking for an annuity. Annuities kind of main objective, I call it longevity insurance. It's you put money in these annuities, and the goal is to, give the insurance company, because they're run by insurance companies, a certain amount of money, and they give you income for life. So if you live past a certain amount, you're going to still receive that income. So it's a type of longevity insurance. It's also, people get annuities because of, protection risk to the market. There's different types of annuities out there that play into those type of fields. I'm not going to jump into the specifics of all those because today I really just want to talk about if you were to inherit an annuity. So really, annuities come in two fashions. You can either get a non-qualified annuity or a qualified annuity, and between those two, the inherited rules are different. So we're going to jump down to the bottom here first. So a qualified annuity. Think of those similar as a traditional IRA or a 401k. So pretty much all you did was take that pre-tax money and you put it into an annuity as an investment. So they still have to satisfy those RMD rules. Remember, got to get it out in 10 years, might have to do some RMDs in years 1 through 9. Spouses have additional options for the most part, but they have to satisfy those rules. Where it gets a little more complicated is the non-qualified annuities. Non-qualified annuities are taxed on the earnings. So one thing that doesn't take place is you have what's called the cost basis and the earnings of that annuity. So let's make it easy here. Let's say there's a $100,000 annuity that you put money in, and it's grown to 150,000. So there's 50,000 in gains there. You've deceased. It goes to your one child. They now have to pay the tax on that 50,000 in gains, and it comes out earnings first. Meaning, hey, you can't touch any of that 100,000 that's not taxable, the cost basis. You actually have to take out that 50,000 out first, which is fully taxable as ordinary income, meaning it adds to your income. But they have options. So, normally instead of the 10-year rule, non-qualified annuities have a normal 5-year rule. So you have to withdraw that out in 5 years. Spouses have the option to keep it as their own and keep it as the annuity as is. You also have the ability to annuitize the annuity or create a stream of payments. That's a way you can prorate some of the taxes off a long period of time. You have to talk to the company that you're inheriting that annuity from. They'll give you kind of specifics on that. But what's fascinating is even with that Secure Act, they kind of got rid of the stretch option for non-spouses. You actually can still stretch out a non-qualified annuity. I don't know why they kept it in there, but you actually still have that ability, which is mean you stretch out the payments over the lifetime, but you need to satisfy certain rules with that. But for most people, they might fall into that. Normally they have to drain it out in 5 years. And what's weird is the earnings come out first. So, to avoid, in this case, that 50,000 of earnings, you're going to have to try to take that out and maybe do, 25,000 one year and 25,000 the second year. Pay those taxes, and then that 100,000 is finally coming out tax-free. There's options here, and you really have to think about the best way for you of when to take this money out of these non-qualified annuities. Because I've seen some in very high earnings, and they don't really like the annuity as an investment because it might have been a good investment for the deceased, but maybe for you it means nothing to you, and you don't want to be inside or utilize the annuity anymore. So what I want you guys to take away from this, qualified annuities, or there's 2 types of annuities you can inherit, non-qualified and qualified. They have their own rules, and they're taxed differently. So take that away from this today. If you have one yourself, really start to research, talk to your tax advisor, talk to a financial advisor. They're going to help you kind of plan out this in the future. All right. Brokerage accounts. Brokerage accounts is what I like to call non-retirement money, or money that they weren't putting into 401ks, getting the extra great tax treatment, or Roths. It's money that, your savings built up past your emergency fund, and now you have this, you want to invest more money. Brokerage accounts, you don't really have that limits, those IRA or 401k limits of money you could put into it. Brokerage accounts, you can put as much money into it as you want, and invest in what you would prefer. So one thing that's very different about brokerage accounts is they have what's called a step up in basis. So to make this easy, I'm gonna say this person only had one holding in their brokerage account. They invested in stock ABC. ABC stock, when they bought it, was worth $5 a share. It is now worth $100 a share. So if you had 100 shares and have a gain of 95,000 or $95 a share, that's 95,000 of gains there, or 9,500. So what I'm trying to get at is you have all these gains from, this stock ABC. If, your child is the only beneficiary, what happens is instead of $5 and having to pay capital gains tax between 5 and 95, you get a step up in basis where your new basis as the inheritor is $95 a share. Which means
If that parent had sold while they were living, what would their taxes be? Or what's that tax form called?
yeah, so let's say that same spouse decided to sell that stock ABC. They would have had to pay capital gains tax on that 90,000, or it's worth 100. It was bought at 5. That $95 a share of gains multiplied by the amount of shares that they own, in capital gains tax, which is anywhere from 15 to 20% of that value, possibly lower if they're in lower income, but they would have to pay tax on it. So many times, if you have these large appreciated amounts of positions, normally it's like legacy stocks that you tend to see it might make sense not to sell those positions. That way your inheritor, whoever inherits the account, gets a step up in cost basis, and they don't have to pay the tax on that $95 a share. So that's what I mean by step up in cost basis. So it's not taxable. Nothing's really taxable at that point. It's from that time of death. If it has increased since then, that's where you might have some capital gains.
So is that why people want to hold on to stuff a lot of times if they have the financial ability to hold on to things until they pass rather than gifting during life?
That's exactly it. You hear a lot about this, we want to gift so we can avoid estate taxes. We'll get into that just a hair later here. But that's the main reason. We want to get these step up in cost basis where, we can help avoid some of those taxes that aren't necessary. Where that kind of plays, and we might have to rethink that, is if that maybe stock position is 80% of your net worth. Now we're running into a problem where you have a very concentrated position, and maybe it might make sense on a risk factor to reduce some of that exposure for your own retirement. So that's when, we start talking about that. And, gifting those assets is another of some of those highly appreciated, is just another strategy out there, but it really depends on your situation. Dividends and interest, just want to touch on that. Any dividends and interest earned on the account until the date of death are generally subject to income tax. So it's kind of weird in brokerage accounts. If you sell out of an investment, there's capital gains tax, but any dividends or interest in those accounts are income taxes. In tax reporting, beneficiaries must report any capital gains if they sell the inherited assets. So this is what I mean. So if they, inherited the asset and it was worth $100 a share, and it, since that time of death, it grew to $105 a share, there's going to be some capital gains that beneficiary still has to pay for if they were to sell that position at that point. What works very similar here is real estate. And Elizabeth, I don't know if you wanted to touch on this. I know you probably run into this all the time.
Yeah, a lot of times I run into clients who want to gift their cabin to their kids while they're alive. And there's, obviously I get an accountant involved and there's sort of a complicated tax analysis you have to do, but a lot of times, and in most cases, you're not going to get that step up. So if you gift it during life, the kids' gains on what you had it for are going to be so significant. Whereas if you would wait till you pass away, give the cabin to the kids, then they get that step up in basis. So any increase after their death for when they sell it, it's going to be significantly smaller.
And that's exactly it. We've had that comes into our office all the time. They have these cabins that, for a cost basis, it's probably worth, 10,000, but as you guys know, housing prices have increased quite a bit, and maybe that same property is worth 100,000. So now there's $90,000 of capital gain that if they were to sell the cabin, they would have to pay that income or that capital gains tax. So just by, instead of gifting it, listing a beneficiary, and that can be done, Elizabeth, I'm assuming through the trust or transfer on death deeds, probably are the two biggest. Those are ways that you can kind of list those and have it transfer at the time of death rather than gifting it during the lifetime. And it's more of a tax question. And that kind of leads into the next. Why do people gift property? Why do people make gifts? And Elizabeth, I want you to go into the estate tax here.
Yeah, so right now, well, in the state of Minnesota, it's $3 million per person. So if the value of your estate is under $3 million, there will be no estate tax. If it's over $3 million, there will. The Minnesota estate tax is not portable, meaning each spouse has to use their full exemption at the time of death. And I'm not trying to get too in the weeds here because these are complicated subjects. And if you work with an estate planning attorney, they'll be able to go through in more detail with you. But the federal estate tax exemption right now is high. It's about 13.9 per person. So that means it's, 27 some million for a couple. Significant. That was set to sunset at the end of 2025 and cut roughly in half to about 6.5 million per person. I've been following this very closely because it makes a huge difference for various clients, but it sounds like that might be extended. That plan might be extended under the new legislative session. I don't know what's actually going to happen, but that means anything in excess of that 13.9 million that you have, if you have that much, is taxed as a federal estate tax. Honestly, Minnesota is one of few states that has an estate tax, but it's something you really have to think about because a lot of times people will then divide assets between two spouses so they can use each spouse's exemption.
And that's where it starts to get a little complicated, and that's where making sure your documents are drafted correctly. Because if they're drafted
and your
wrong,
assets are titled correctly too. If you have brokerage accounts, a lot of times clients divide them between the two spouses rather than having the one spouse own the entire brokerage account. Or if one of the spouses has a huge IRA, then maybe the other spouse owns the brokerage account. And that is when the intersection between financial planning and estate planning becomes so important, because if you're anywhere near that range, you should be talking to someone and figuring out what you want to do to minimize estate taxes. Because as far as I'm concerned, I think most people want to avoid paying estate taxes if they can, or minimize them to the extent they can.
Yeah, I've never had someone come in and say, "Hey, I want to pay the most amount of tax." So, that definitely makes sense. And the state tax, even if you're not alive to see it, it definitely is a real tax there. So, power of attorney.
Yeah. So, the basic main documents are a trust if you go with one, a will, a healthcare directive, and a power of attorney. A power of attorney is an extraordinarily powerful document. It gives another individual the ability to act financially on your behalf while you are alive. It's only valid during life. But if I sign a power of attorney giving my husband authority, he can go to the bank and act as me. They're very powerful, but they're very helpful. I have seen situations where people are out of the country and they need their kids to be able to wire them money. They can use the power of attorney. Where it's one person and they are getting out of surgery and the kids need to sign off on something financial. great situation. I have to emphasize how powerful they are. They're really good to have, and I like most people to have them, but they're super powerful because that person can act financially as if they were you. They can either be springing or durable. Springing means that it's effective only in the event you are incapacitated. A lot of my clients like to go that way. They want to say, you know, I don't mind someone being able to make financial decisions on my behalf, but I only want that to be in the case if I'm incapacitated. Or they're durable, meaning they're effective all the time. I have clients who've been married for 60 years and they say, my spouse has full access to my bank account. I don't care. I trust them. I have no concerns about it. It's really a matter of your situation, but you do have that option to make it a springing power of attorney or a durable power of attorney.
Yeah, and just touching from an advisor standpoint, many IRAs are just held in individual names, and if we're not able to get a contact with them, I mean, technically we can't talk to the spouse about their individual account unless there's a power of attorney on file. So you don't know what could happen. I mean, car accident where they're not, still alive but can't make any decisions. It's these type of things that we see on the advisor side that, hey, we really want to get these drawn up. And I just say, hey, make sure it's someone you can trust. Elizabeth just pointed it out. Hey, these are very powerful documents, and if the wrong person has that power, it could go sour. So, got anything there, Elizabeth?
No, I just no, we can go to the next slide and I can get into it.
Perfect.
The power of attorney, really all estate planning documents. I hope everyone on this webinar lives forever, but there are a few certainties in life, and unfortunately death is one of them. But there are also things that you need to plan for even while you're living. And there are certain circumstances where you need someone to be able to act financially on your behalf. And we're going to get into the healthcare thing after this, but for now, just the financial. There are a lot of situations where you want someone to have the ability, if they need to access your finances. So they're good in that way. I also hope that everyone on this webinar never needs a potential conservator appointed. And a conservator is someone appointed by the court that will act financially on behalf of an individual. If you have a power of attorney for a person, they could use that rather than having to go through a conservatorship proceeding. Those are highly contentious, expensive, really emotionally painful proceedings. Whereas if you just had a power of attorney for your parent and they developed dementia, you can act financially on their behalf with that without having to go through the process of having a court-appointed conservator.
Great. And then kind of finishing off here, healthcare directive.
Yeah, so I think a lot of people think healthcare directives are really only important for older people. So grandma, we want to make sure grandma has a healthcare directive in case she slips or falls. True, I want to make sure grandma has a healthcare directive, but I have run into this over and over again. And something that is so important is the moment your child turns 18, HIPAA restricts doctors from talking to you about your child. And I've seen, unfortunately, cases where kids go off to college, something happens, and the doctors won't talk to the parents. So healthcare directives aren't just important for, older people. They're important for young people. They're important for anyone 18 and older. And they give someone else the authority to make healthcare decisions on your behalf in the event you are unable. Doctors want to hear what you have to say, but if you are in a coma or you can't make your own healthcare decisions, you want a family member or a friend or someone to be making those decisions. You also can provide a lot of information in those. Typical things are whether you want to be cremated or buried, whether you want to be an organ donor, but a lot of times it's just for someone's coming out of surgery, who's going to make decisions about them. And, you want your spouse or your parent or your sibling or your friend, and you don't want someone that you don't know to make those decisions. I think that the healthcare directive is one of the most important documents that every adult should have.
Yeah, no doubt. We don't know what life throws at us. So, if we have the documents in place, it makes it a lot easier, especially, normally when people start thinking about this, it's during a time of either it's too late or a time of pain. And
right.
That's what we don't want to go.
And, that's a a true statement, Vince, in that a lot of times then you have the two kids fighting with each other about who should be making decisions. And it's painful because a lot of times it has to do with a parent or it has to do with a kid. And if you can set that out in a legal document so that the doctors can look at that and look to who they need to be talking to, that is hugely important.
Yeah. And that's, that kind of sums up what we wanted to discuss today. I know we just scratched the surface of some of these estate planning topics. And like I mentioned before, if we really want to get in the weeds, it's a 3-4 hour conversation or presentation, and then there's still going to be questions after that. So I hope we gave you enough to kind of get the wheels turning and start thinking about, hey, do we have these things in place? Do we have all our things properly labeled, assigned? Do we have our documents? Have we even looked at our documents in the last 20 years? These are all things that we wanted to bring up today as we had this presentation. So Elizabeth, anything last words from you?
I don't think so. Update your plans, review your plans, update your beneficiary designations. You owe it to your spouse, your family members, your kids, everybody. So make sure you're on top of it, because I know it's the last thing people want to spend money on, but it is so important and almost everyone needs something in place.
Awesome. Well, thank you, everyone. Molly, we'll turn it to you.
Perfect. Well, thank you, Vince and Elizabeth, for breaking down this important topic.